Welcome back to the channel, friends. This is your Govindraj. Thank you very much for watching my previous videos and your shares and also your likes and comments. In this video, we are going to talk about exclusively on contract employees' responsibility of principal employer in case of Provident fund dues. So we are going to look at the EPF and Miscellaneous Provisions Act 1952 provisions as in the text, and also we are going to look at certain judicial interpretations and case laws, so that we are clear what is the law is talking about and what is the stand of the courts of India. So we are going to understand this important aspect, and it is important for us also in terms of compliance and taking care of compliance of contract employees. And we are also going to look at what is there in the labor codes regarding this subject. Is the current status is going to be there, or is there any changes? And we will also look into a new feature which is added in the employer portal of EPFO, where you can actually upload the details of the contractors and PF wages and payments and check whether your contractor has complied to such payments or not. So that is very important. So we are going to understand this aspect also. So now let's proceed, friends. So if you have to understand what is the law is talking about, we will look into the text of the law. See, if you look at section 2F of EPF and Miscellaneous Provisions Act 1952, this is talks about employee definition, and it definitely covers employees engaged through contractor. So there it is very clear that the EPF Act covers contract employees as well. And importantly, section 6, if you look at it, clearly fixes the responsibility on the principal employer to pay contributions for each of the employee, whether employed by him directly or by through a contractor. So basically it is on the principal employer to pay the contributions of contract employees also, as per the text of the law. And we will also see what is the judicial interpretation about it. And of course there is a option is retained to the employer, where he can recover the contributions of contract employees from the payments which are belongs to contractor. Now you can look at section 8A. It is definitely gives you these provisions, and this is about the text of the law, what is available in the Employees Provident Fund and Miscellaneous Provisions Act 1952. Now we will look into the scheme provisions, where this EPF scheme 1952, especially paragraph 30 of this scheme, clearly mandates the principal employer to pay the contributions along with admin charges, that is administrative charges, of employees employed by him and also engaged through a contractor, very important, with an option to deduct the employee contribution from employees. And also it casts the responsibility on the contractor to pay both contributions to the principal employer. So this is what is available in the text of the law and schemes. Now it is important that we understand what do the courts of India are talking about. If you go as per the literal constructions of the provisions of EPF Act 1952 and also EPF scheme 1952, it is very clear that it is the responsibility of the principal employer to take care of the contributions of contract employees, especially provident fund contributions. Now, is there any difference between the interpretation and what is the literal construction? Now if you look at, initially the courts of India have held that the principal employer is responsible in case the contractor fails or if he doesn't pay. Or it is very clear that in the initial case laws, you can go to this history and read about it. You will see definitely making principal employer responsible for contract employees. However, this stand is neutralized after certain period of time, and this was modified by the courts of India. Now I am going to tell you what are the key principles laid down various high courts and also the honorable apex court, and I am going to tell you certain key principles where it is going to help you to understand this subject very well and also implement in your establishment. The first principle which came from out of the case law in the court of law, the first one is contractor or manpower supplier, who is basically a manpower agency. Their relationship is based on principal to principal. for PF purpose. This is held in one of the case. So I'm going to give you these cases at the end of this video, and so that you can go and refer to it. So this is one of the important principle where this contractor or manpower supplier and the relationship with the employer is based on principal to principal. That means when these people are called as principal to principal, then there is no question of the contractor and the principal employer. So therefore the contractor is going to be responsible for provident fund contributions. And also in one of the case, it was so held that a direct supervision on the contract employees, it can make the employer responsible for PF contributions. So therefore, while engaging the contract laborers, you should be very careful on this aspect. And payment of salary directly to contract laborers can also make him responsible. So this is one of the principle also laid down in one of the case. And employer-employee relationship does not exist with the principal employer if the contractor has valid license under the Contract Labor Abolition and Regulation Act, and wages are paid by the contractor directly to the contractors, and EPF or the UAN number currently is allotted through the contractor code number. So this is one of the important principle which was laid down in one of the case. And also, if the contractor is allotted with the independent code number, then the contractor acquires the status of independent employer. So this is very important. So if he has got already the code number from the EPFO, then he is treated as independent employer, and his concern achieves the status of establishment. So therefore the law is going to mandate the contractor on achieving this status, not the principal employer. See, however, the employees of contractor who has no code number are obviously the responsibility of principal employer by virtue of paragraph 30. So therefore it is important to make sure that these principles are understood and you comply the contract labor issue in your establishment. So these are the cases which basically which I have referred of. In some of the cases it was also held that even if there is no license under the CLRA, it is not immediate that the the principal employer is responsible for the contract employees, but these are all based on certain circumstances and facts. Therefore you have to be very careful while concluding on these issues. So now, what are the learnings we have got through? Basically, we understood the text of the law, we understood the judicial principles. Basically, the learning is no direct supervision on contract employees, no direct payments to the contract employees, and valid registration for principal employer and license for under the Contract Labor Regulation and Abolition Act is very much necessary. And don't hire a contractor who has no independent code number under Provident Fund. So if he has no code number, definitely it will be on the principal employer, and tomorrow the authorities are going to hold the principal employer responsible. And also ensure that the contractor has registered his establishment under the applicable law. It could be shops and establishment, it could be Factories Act, whatever it is, the applicable law under that he should have been registered validly under the law. And ensure a proper contract with precise terms and conditions and very clearly explained, and also fixing the responsibility on the compliances under various labor laws including social security legislations. This is very important. And also check the compliance of the contractor very periodically, so that you are very sure about it. Now we talked about the existing law. Now you are already aware that tomorrow this is not the status. The labor codes are going to come. If not today, tomorrow. The government is talking about already from 1st October the labor codes are going to be implemented. But I am not sure. But today or tomorrow these labor codes are going to be definitely implemented. So we should also look into the labor code provisions, whether the current status is going to be continued on the responsibility of the Provident Fund dues for the contract employees, and try to conclude on that. If you look at the labor codes, especially the Code on Social Security 2020, section 16 still retains the responsibility of principal employer for contract employees, and also retain the option to the employer to deduct the provident fund contributions from the amounts payable to the contractor under section 17. And if you look at the employee definition under section 226, it covers employees employed directly or through a contractor, and principal employer is not directly defined in the code, but the employer definition defines an employer as one who employs directly or through any other person. So therefore the employer definition clearly indirectly also says that a person who employs people indirectly is called as an employer, rather than also meaning the principal employer. And but very importantly, now the code is defined the the contract labor and contractor separately, and contractor is included as an employer very specifically under the employer definition. You can go to section 227. This is very clear that the contractor is also included as a employer for the purpose of the code. See, this means then the contractor is going to be liable more and more, fixing very important responsibility on him, and in case of non-compliance he can also held be responsible as employer for all the purposes of the code. Now coming back to whether the courts of India are going to retain the current interpretation about the provident fund use in case of contract employees or not is very important. In my view, and considering the definitions and also inclusion of contractor as employer, I am of the view that the current trend is going to be continued, and there will not be any change. Of course, we have to look into the facts of the case, what are the things are put forth before the court, and we should be very cautious and understand what is the interpretation, and probably we can conclude. And similarly, with all this, you have to ensure that the employment of contract labor is legal, and the learnings and conclusions what we made in this video have to be compulsorily followed, so that your employer and the principal employer are not put to great risk and liability in terms of money. So therefore it is important that you clearly understand these principles and follow. And in case of ESI, similar principles can always be applied for these payments. But however, considering the text of the law, ESI Act 1948 and the Code on Social Security 2020, and the judicial interpretation with reference to ESI Act have to be looked into, and we are going to do this kind of analysis in the future videos. And therefore please subscribe this channel, and also stay connected so that you can get more and more updates on this matter. Now, I also talked about initially that the EPFO has added one important feature about the checking the contractor compliance by updating the contract employees details in the principal employer portal. So now let's look into what is the portal is giving you this feature. So friends, now let's look into this new feature which is added in EPFO employer login about contractor complaints. So as I said already, by this you can check your contractor complaints whether he has properly paid the contributions or not. So, and of course accordingly you can talk to your contractor and make the complaints properly. So now we are going to the EPFO employer portal. You can go to Google and type EPFO employer portal. Then you get a link, EPFO unified portal. You can click that, and then of course if you have already saved this URL, you can directly go also. Then you type your username and enter your password. So now you are into your employer portal, and of course you will immediately get this message. You can check verify later and then continue. So then after that, if you go to your establishment section, here there are two important features are added. One is the contractor and the principal employers. So about this topic we are going to discuss in the next video, how to add your contractor and how to upload your file and what are the errors you may get it, and how to check the complaints in the dashboard. All these things we are going to look at in the next video. Until then, I will take a leave from all of you. And if you like this video, and if it is important for you, and if it has enhanced your knowledge, Please do subscribe the channel, share it in your groups and contacts, and your likes and comments, and also sharing it in your network are very important, and all these things will definitely promote this initiative to be continued. Thank you very much, and see you soon with a new video and new information. Thank you, and see you again.